Before we move on to ownership, there is one more topic that I want to discuss, and it's subject matter that is not subject to copyright. I know when we started the discussion, we talked about things like facts already, and we've talked about ideas and words and slogans and titles. Those things are not subject to copyright. I want to expand a little bit more because there are some other areas that are not, and it might be easy to say copyright does not protect ideas, but in reality it's hard to apply. It's sometimes hard to distinguish these non-copyrightable ideas from copyrightable creative expression of those ideas. An author has an idea for a short story. The idea itself is not protected, no matter how original that idea is. Same if an author writes a letter to, a wannabe author or an up-and-coming author writes a letter to a famous author stating, hey, I got this great idea for a short story, and then the famous author steals it and writes it into a short story or a novel. That's not infringement. And the Copyright Act expands a little bit more and says copyright does not protect ideas, and in fact it says in no case does copyright protection for an original work of authorship extend. So it could be something that's already original, something that's deemed original and a work of authorship, and possibly even put down in intangible form. But no way does it extend to the copyright protection extend to any idea, procedure, process, system, method of operation, concept, principle of discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such a work. So we're already past the 3-step rule, and we can get to this point, and the work may not be subject to copyright protection. A movie's premise, the idea that makes a song memorable, or an idea of a new product, or a legal brief that lawyers write, and they might write out this great argument applying the statute of law. That is unprotected, no matter how creative and verbose and that the attorney puts it in. A paper in a biology journal may prose a new interpretation of some fossil, and that theory is not protected. A copyright work may contain many ideas, right? There could be the overall idea for a movie may be what happens when the Chicago Cubs finally win a championship, or that you could take that concept and the movie can be built on many other ideas. So, or a book of science may have a bunch of ideas with regards to the science, but it's not protected. You can write a how-to book, how to do A, B, and C, and then somebody takes A, B, and C and does those things. The author can't say, well, that's copyright protected because I wrote it. That's not how it works. The way the author expresses the idea is what's protected. So why aren't these ideas protected? Well, the second question is, why aren't they protected? Are they less valuable than the expression itself? Might be a great idea. Congress didn't want to provide incentives for ideas alone. They wanted creation. Also, ideas, it stops the free flow of ideas if you grant one copyright in an idea. Right? But then if you don't give a copyright in an idea, then is there sufficient incentive to create? Well, if I'm going to create something and this particular thing is not protected, then why bother? But then also the whole point is to continue creating, so you build on these ideas. And we're going to talk about these in more detail, with more examples and lots of cases. So, I write a novel. If you copy it word for word, it's infringement. I write a song and it's copied, word and notes and melody, detail by detail, it's infringement. The idea behind the song is not. Lots of country songs have the same idea. Man loses lover and is sad about it and wants to get her back, right? Isn't that the whole premise around country music? Isn't that the theme? Lost my lover and I'm sad and I want her back. That's the idea. Lots of songs, country songs, have that concept. That's the idea, and that's not what's copyrightable. The song itself, or the expression, is. So ideas might be concepts or solutions or some sort of building block. Concepts, an example of concepts that are not protected, game shows, contests, parades, those things, those are just those are not protected, those are not expression. That's copyrighted under the statute. Works that have a solution, rules for how to play a game, a design of some form. These are all building blocks. Plots and themes of books, colors and shapes in a visual work, rhythms and notes in a musical work. Of course, there's a very fine line in musical works, and we'll see when we talk about music. Music's got its own week, because it has a little bit more, not complicated, but there are a little bit more interesting rules relative to music that don't always apply to the other forms of expression. So these things are considered building blocks. A biology book. Talked a little bit about this with history books, the same thing. Publisher wants to create one that competes with another. May it copy the overall structure and organization, how the material is divided into chapters, selection of topics. The facts themselves are not copies. Anyone can write a book on copyright law. I have several different books that I've taken from to express this information and condense it down for this course. I can use that information that's in the book. The Copyright Act is not copyrightable. I can actually copy that word for word. That's in the public domain. But if I took one of these books and read it cover to cover and copied it cover to cover and handed it out, that would be infringement. But I can take the facts. I can just create them my own way. Same thing with a biology book. If a bootlegger sells posters of a copyrighted painting, copies of novels, we can agree that that's infringement. It's literal copying. But what copyright must do more than just protect against literal copying, right? Otherwise, you just take a few words, switch it around, then you got a free ride. But there also has to be some level of copying. Not everything is this brand new concept. Everything builds upon something that's already happened, whether it's already in the public domain or on somebody else's work. And we're going to see a lot of that when we get to, fair use. But we're going to look at some cases right now. Courts have, I got to switch my slide. This is going to be the test that we're going to use when we're determining whether something is an idea or expression that should be protected, whether giving protection to the copied element would reduce the ability of others to create works, whether others are left with plenty of alternatives. That's what the court is looking at. And that's the key role that's playing in this. And when we actually talk about infringement, there will be a test for it. But right now what we're talking about is, well, how do we know something is somebody's idea or its expression? So that's the series of cases that we are going to delve into. And we're going to start with elements that necessarily follow from an unprotected idea are unprotected. What? What does that mean? If a play, let's take this for example. If a play is set among immigrants in New York in the early 1900s, what's that setting looking like, right? That setting largely determines elements of how people dress, the manner of speaking, the types of vehicles, the elements of the scenery. These things are unprotected ideas, because any one of us can write a play or a story about immigrants in New York in the early 1900s. And we would need all of those things to tell our story. Just like a detective story that might be set in a monastery. There's likelihood that we're going to have several suspects who will probably be monks. If these elements were protected, what can happen? No one else would be able to write a story about immigrants in New York in the early 1900s. They would have a specific copyright. So you need more than just the regular elements that follow. More than the original idea, right? That's the original idea. A science fiction work, let's call it way of a science fiction work called Dune. D-U-N-E, Dune. And the original premise of a world in which water has become truly scarce and must be conserved with heroic means. That's what the science fiction work is about, right? Original premise of a world in which water has become truly scarce and must be conserved with heroic means. That is an idea. This is my idea for a book. That is not protected. Anyone can go and take that and freely write. What's going to be obvious in more than one work? What's an author going to have to do under that premises? Any author. They'd be free to write their own, we'll call it a sci-fi novel, set on a planet where there's very little water. What specific elements might we need? Water would be fought over. Individuals will carry devices to minimize water usage and waste. Landscape would be dry, be like the desert. These would have to be common elements. That's not infringement. These are ideas. I can write a book, make a kid's TV cartoon about a dinosaur living in a zoo in New York, and he's struggling to get home to his family in an island off the coast of Costa Rica. And he gathers his friends around in the zoo, and there could be an elephant, and there could be a fox, and there could be a hippopotamus, and there could be a raccoon, and they're all going to work together to help the dinosaur get back home. So what are we going to have? We're going to have all of these animals. We're going to have a zoo. We'll probably have a zookeeper. And I can write that cartoon. My friend next door can write a cartoon about a dinosaur in a zoo, and he has all these friends, the elephant, the rhino, the fox, and the gist of the cartoon is the dinosaur just arrived and they're brand new, and these guys are welcoming in the dinosaur, and he likes the new zoo, right? Different story. Same elements, the same need for these characters, and that is fair game. These are ideas, these are concepts, and it's called scena faire. That's our fancy word for this. The doctrine stands for scene to be made. The scene that must be done. That's what it stands for in French. Elements of a work that may be unprotected if they are commonly found in a work or a genre. Right? Spy novel is expected to contain elements of, Swiss bank and spy gadgets and things hidden in like wristwatches and belts and so forth, right? Scena faire, the unprotected elements. And the policy behind this doctrine is that granting a first comer exclusivity over these scena faire would do what? Greatly hinder others. in being able to subsequently create other expressive works using those things. So now I'm going to show you a few cases involving this. Let's take a look at this here. I'll give you a little background. This is Steinberg versus Columbia Pictures. If you're not familiar, there's a movie, Moscow on the Hudson. It's from the 80s, I believe the late 80s. And on the other side is a magazine cover from the New Yorker from 1976. So the owner of the New Yorker, Steinberger, sues Columbia Pictures over their advertisement for their movie Moscow on the Hudson. So why don't you take a peek and see if you see any similarities as I tell you about the facts of the case. I'll probably skip around a little bit here to tell you it was a big case. There was a lot of issues. We're just talking about the one involving Senefer. That was the defendant's argument. We didn't copy that. We just copied the non-protectable elements, like the ocean, the Hudson River, a city block. We got Russia in the background over there instead of Jersey. What do you think so far? Well, here's what the court had to talk about. Let me point out some key facts here. So, defendant created this illustration, and the art director for Moscow on the Hudson had admitted that he specifically referenced this Steinberger cover of the magazine, which was later, after it was on the cover, it was the cover of the New Yorker, it was turned into a poster, and the poster was in fact hanging on the art director's wall for years. He had purchased it and he hung it up. And he noted that he specifically directed the outside artist who designed Moscow on the Hudson that he'd want it to be somewhat like that. And the illustration here presents like a bird's eye view across a portion of the western part of Manhattan, the scope view. And what about the lettering? You think the lettering is similar? Moscow on the Hudson, the New Yorker, that was kind of pointed out by the court. The lettering was kind of drawn very similar, even at the bottom. Even the lettering on the Atlantic Ocean versus the Pacific Ocean. Hudson River. There's no boat in the Hudson River on the New Yorker. See, would you let this go? Do you say this is copy, or you say this is Senefer? By the way, this case is in the book. If you want to read all the details, I'm going to point out bits and pieces. And at the end of the case, there's actually two other illustrations that spun off of the New Yorker, but they were from out of the country. So take a look at those. So the defendants argue that their poster could not infringe on plaintiff's copyright because only a small portion of its design could possibly be considered similar. The map, that is the portion about the plaintiff, is what they're complaining about, is the design was separate from the rest. The court rejected that argument that said any similarities between these works are unprotectable as Senefer or incidents of character settings, which as a practical matter are indispensable or a standard in the treatment of a given topic. So the court is already pointing out the fact that this may constitute as Senefer. I'm sorry, that was the defendant's argument, not the court. I keep saying the court, the defendant's argument, that these are Senefer and they couldn't possibly be, because you need a city block if you want to do New York City, right? You're going to need the Hudson River if you want to do New York City. That these are all Senefair. All right, let me tell you what the court said. If we were in class, I'd take a vote, tell you what, see what you guys thought. But the court ruled that this was infringement. This constituted infringement, not Senefair. And the court had specifically stated that, I'm trying to find the appropriate language in my case, but the court really hung its hat on the fact that the art director had the poster hanging in his office and specifically directed that the poster be used. And while it did note that it was okay that the defendant used the idea of a map, the striking similarity to the posters, to the advertisement to the posters, was something that couldn't be overlooked. And they did reject the Santa Fe argument. It's undeniable that a drawing of New York City blocks could be expected to include buildings, pedestrians, vehicles, lampposts, and water towers. However, it's the complaint that the defendant has gone above mere use of those elements and copied the entire expression of those elements of a street scene. So they rejected Senefair. So there is one example that Senefair is, that this is expression over idea and using the Senefair elements. Let's talk about a different case. I got a bunch of cases. We're going to go through this. This is important. This is an important concept. This is what cases turn on when they are brought to court for infringement. Remember the case involving the Kevin Garnett photo? There was discussion regarding Senefair and the use of standard elements, and it was rejected because they flat out copied the expression and how they posed the basketball player or the model to make it look like the other photo. All right, Nicholas versus Universal Pictures. So we're talking about ideas versus expression in creative works. And this case involves the plaintiff, who is the author of a play called Abby's Irish Rose. Defendant produced a motion picture called The Coens and the Kells, which the plaintiff claims was taken from its play. Both plays portray stories of a Jewish and an Irish Catholic family in which the children fall in love and are married. Their parents are outraged, a grandchild is born, and there is reconciliation that follows. And the question is, may the plays in the picture be similar enough in plot for finding an infringement? So the case involves the question of what extent ideas may be subject to copyright protection. And here, the general point, the court makes out a few general points and then gives its position. It says as a general rule, the idea expression dichotomy holds that ideas are never copyrightable, though the expression of those ideas may be subject to copyright protection. While a plot is more of an idea, the court recognizes that in some cases the play may nonetheless be copyrightable. However, it says not in this case, and here's why. It appeared that while the plot was extremely similar, the defendant took no more of the plaintiff's work, assuming he took anything at all, than the law allowed. Both stories were very different, the only similar point being an argument between an Irish father and a Jewish father the marriage of the children, the birth of the grandchild, and the reconciliation. The plaintiff's copyright did not cover all that. That might be drawn from her play. Its content went to some extent into the public domain. The theme was basically an idea, and that the characters were mainly stock figures, quote unquote stock figures. We're going to talk about figures next, which have been used many times for decades. Obviously, using, a Jewish family and an Irish Catholic family, there was no detailed description regarding a specific character. Back to my example, if you're trying to do a movie about immigrants in New York in the 1900s, you're going to need certain types of characters. All right, so Nicholas versus Universal. General elements are not infringement. Those stock characters are free and fair game to use. I can write a book about a wizard boy who has to save the world. That's not just for J.K. Rowling's to do. I wish I had a good idea for one, but I don't. All right. So let's talk about characters. Now, I'm going to talk about a case, MGM versus Honda. And there is a link. I don't know how you guys are viewing this, but there is right below this video lecture is the commercial that Honda made for their car, the Del Sol. I think it's called the Del Sol. You should watch it. Stop this and watch that for a minute, because that's what I'm going to talk about. If you're able to stop and pause and pull it up and give it a watch, it's a commercial. And the gist of the case is that MGM sues Honda for using a James Bond-like character in that commercial. And Honda's argument is James Bond. This is like we didn't call him James Bond. This is like a spy man movie kind of scene. The MGM argues that the James Bond character, as expressed and delineated in the 16 films, has given it its copyright. We're not saying we have a copyright in James Bond. We have a copyright in James Bond character as expressed, specifically in detail in those films. What the plaintiff is not claiming is that plaintiff has plaintiff has a copy in the James Bond character itself, but rather in the James Bond character as expressed in the film. So here's how the story goes, because we're going to talk about characters. Is there a copyright in Harry Potter? Is there a copyright in Superman? Is there a copyright in Mickey Mouse? Characters. In Nicholas versus Universal, general elements, those stock figures, there isn't. But when does a character become copyrightable? The defendant responded to the plaintiff as simply trying that the defendant responded that plaintiffs are simply trying to gain a monopoly over the action spy police hero genre, which is contrary to the purpose of copyright law. There was a case we have two tests that come out of this. We have a case out of the Ninth Circuit, which is the highest federal court in California. And we have a case that comes out of the Second Circuit, the highest court in New York. And you're going to see that these two always come up with different concepts or rulings. It's actually, to let the cat out of the bag, the last week of class, there's a writing review assignment, and it's one of these California versus New York kind of cases. I'll have you analyze. But facing one of many right now. So in the Ninth Circuit, the court said that in order for a literary character to be copyrightable, there needs to be more than just the storytelling, the story being told, like the narrator of a book, right? If you're reading a book, it's told from a certain point of view. And if it's the character narrating the book, it might be the protagonist. It might not be a character, it just might be the narrator. You need more. Well, that in a literary sense, you need more than just the storyteller before you have copyright protection over your character. Okay? So that's number one. Then Disney went to bat over Mickey Mouse. And these were over comic book characters who were protected, who Disney claimed were protected by copyright, and that book characters are distinguishable from literary characters because you can see them, right? They constitute not only the story being told, but as a practical matter, they are graphically depicted characters. They're much more than the literary character. They're already fleshed out. They got a face, so they warrant more copyright protection. And in fact, that was the case. But the Ninth Circuit still has the story being told test. You need more than the story being told. And this Disney case came out of New York, which is the character has to be delineated enough. Character delineation, like how much are they described. And in this case, James Bond character as developed in the 16 films was sufficiently unique and deserves copyright protection. That's what the judge said. And actually, James Bond is not the story being told, but instead has changed enormously from film to film, from actor to actor, and from year to year, that's what the defendants claim. And they contend that it's not so much delineated, but the court disagreed and said that under either one of these court tests, James Bond is a character that has been developed sufficiently, even beyond the story. The 16 films is the story being told of James Bond. And the judge went on to compare James Bond to Rocky Balboa, right? Sherlock Holmes, Tarzan, Superman. So, characters, if distinguishable and described enough, they will get copyright protection, more so than just the one who tells the story. So far, so good? All right. Let's talk about another concept. In factual works. We're not going to spend a lot of time here because I think I've brought this up many times already. The scope of protection that is affected by the degree of originality, the facts and the theories, right? Works that convey unprotected materials are more limited to protection than a work that is principally creative, which is kind of interesting that a work of complete fiction like a goofy comic book will have a thicker copyright protection than a very thoroughly researched out biography on Gandhi, by the way. It is what it is. I do have a quick case with regards to this. Ho Ling was a historian who researched the Hindenburg disaster. He published a book. It's based on several other sources that blamed the disaster on the work of sabotage. Later, a fiction writer named Mooney wrote a novel about the disaster that featured a plot and characters similar to the plaintiff's research. It was later then turned into a movie, and the defendant Mooney admitted that he used Ho Ling's book as a source of its novel. However, he changed the names of the people and deviated from historical fact on a number of occasions. Ho Ling sued Mooney and Universal City for infringement. Ho Ling argued that Mooney copied the essential plot of his book. Mooney argued that the plot is an idea and ideas and not copyrightable as a matter of law. In addition, Mooney argued that historical facts are not copyrightable. Since historical facts were somewhat unclear, the plaintiff argued, Ho Ling argued, that his interpretation of the facts was original and therefore copyrightable. And the This went this is again a New York federal court, the Second Circuit. Trial court found for the defendant, and of course the plaintiff appealed, but the appellate court agreed that the historical facts were non-copyrightable. The court found in works devoted to historical subjects, a second author may make sufficient use of that prior work, so long as they do not bodily appropriate the expression of the original, so how it was expressed. So, public policy issue to ponder. There's a public policy reason for allowing many people to research and produce accounts of historical events, but on the other hand, if a person can't get protection for all their hard work, then it kind of inhibits people from producing accounts. And so in this instance, if he went through all of that work and, if the facts were unclear, he used his own interpretation of those facts, and that could be deemed original, but nope. So anyway, facts. We've talked to that one at length. Merger doctrine. Very similar to Senefer. This is when ideas can be expressed only in a few ways. To the extent that the idea constrains its expression, the expression is going to be unprotected. These are really limited examples. There's not a big threshold of examples. When we were talking about Senefer, we're talking about novels and novels, stories, movies, that sort of genre. When Senefer, it kind of comes into play. Merger doctrine, we're talking about, illustrations, such as a product label. Usually creative drawings fall in this category. Let's take a product example. And you're selling, strawberry scented candles. What are you going to put on the cover to express strawberry scented? A strawberry. It's not many places you can go with that, right? Same, strawberry jam. You're going to put strawberry. There's no other way to express it. So in that sense, that wouldn't be protected, that label on that strawberry jam or that strawberry scented candle, because you can only express it one way. If you're painting a sunset, one person paints a sunset, it's copyrightable? No, there's only one type of sunset. You need a sun and a sky, and there's only so many ways to do it. So, while it may turn out differently, nobody has a copyright on a painted sunset, an ocean scene, a beach. A beach can only be expressed so many ways, right? So that's what the doctrine of merger is. If the underlying idea can effectively be expressed in only one or very few ways, the idea and the expression are said to merge. And that is not copyrightable. Okay? The merger doctrine. A few more concepts here. This one's running a little bit longer than I anticipated. This is a big topic, though. In no case does copyright protection for an original work of authorship extend to any idea. Let's talk about this: procedure, process, system, method of operation, concept, principle of discovery, regardless of the form. The aspect I want to take from here is the copyright does not protect functional aspects of work. Okay? So copyright applies to original creative expression. As discussed, copyright protects only the elements of the work that are creative, such as the particular ways an author expresses an idea, but a copyright doesn't protect the idea. And copyright also does not protect functional aspects of work as opposed to their expressive aspects. So an example, the original safety procedure for scuba diving, the original process for domesticating wild berries, the original system for running a dental office, or the method of operation for a rocket ship. These types of things are not copyrightable. They may be viewed as ideas, but they're not copyrightable. and there's some functionality component. With ideas, elements, they generally revolve around the question of whether they should be copyrightable or left in the public domain. That's with the ideas and the elements. With functional elements, you have a dividing line. It's different. They may not be copyrightable, but they might be what? Patentable. Might be patentable. So the question becomes whether an element of work is creative and therefore belongs in the copyright realm, or it is functional and therefore it's patent protected. So let's talk about Baker versus Selden. Mr. Selden, he obtained a copyright in a book that explained a system of double entry bookkeeping, but with a particular arrangement of columns and headings which presented the entire operation of a day, a week, or a month on a single page, or on 2 pages facing each other in an account book. This case is in the book, by the way. Defendant uses a similar plan, but makes a different arrangement of the columns and uses different headings for the columns. And the plaintiff says that the defendant copyrighted his double entry bookkeeping system. And the court said, no, that's not what happened here. Any author may explain the truths of a science or a method, that's what he did here, a method of an art that are the property of the entire world, and get a copyright in that work. So his book that he wrote about it, there's a copyright, but the method inside is not. An example I gave a little while ago, you get a self-help book. The self-help book itself is copyrightable, but the information inside that is functional is for anyone to use, right? That copyright, however, does not extend to the method or use of the system described. The system is simply not subject to copyright protection. To protect a system, the author would have to apply for a patent and meet the patent requirements. Awarding protection on the basis of the copyright in the book would be a fraud on the public. So that is a method being described in the book. The method is not protectable, not copyrightable, I should say, not copyrightable. But I will note that some useful ideas are a little bit too abstract for patent protection, but we're not going to talk about patents. Different elements of the same work might be protected by both, though. You might have a creative elements of a computer program that will get copyright protection. The program may implement patentable inventions, like the method of performing certain tasks. And of course, we may have a trademark protection on the product as a whole. So this is where they all kind of, a concept where they all can kind of come together. And this rule for copyright, this rule that copyright does not protect functional elements, does play a role in the everyday world, like events and behaviors that are recorded every day, security cameras, personal video recorders, gaming and virtual software. They may be regarded as works of authorship, but they might be simply functional or have factual data composed in them. So maybe not everything involved in that is subject to copyright protection. All right, Baker versus Selden, we did that one already. And let's talk about this one. As I was talking about functionality, this is a U.S. Supreme Court case. Mr. Stein created and registered for a copyright in this sculpture of a woman. This is a sculpture of a woman, which was then manufactured into a mass-produced lamp base. So on top of this is a lamp. So this is a base of a lamp. And the defendant subsequently manufactured similar lamp bases, and Stein filed a copyright infringement. The trial court found in favor of the defendant, Mazar. on the grounds that copyrights are not intended to protect utilitarian items, functional items such as a lamp, which resulted in an appeal, and the appellate court agreed with the defendant, finding that a subsequent utilization of a work of art in an article of manufacture does not preclude the copyright owner to be protected from the infringement of the work itself. And of course, Mr. Mazur appeals, and this goes all the way to the Supreme Court. And this is also in the book, by the way. And the question was whether or not there is a copyright in this base of the lamp, despite the fact that the lamp is a useful item. And the Supreme Court said, yes, there is a copyright in the base of the lamp. Upon reviewing the history of the successive copyright acts and the legislative history, the court found that a quote-unquote work of art has a broader specification than just a work of fine art. A work that is the result of the original, tangible ideas of the creator is subject to copyright protection. Thus, the court finds that the lamp base satisfies the requisite originality needed for protection. The court also noted and reasoned that the lamp base, fitted as lamps or unfitted, may be granted a design patent, but patentability does not bar the base lamps from being copyrighted as a work of art. Furthermore, the court found that the intended or actual use in industry of an article eligible for copyright does not bar or invalidate its copyright. So here this case is an original idea that gets incorporated into a utilitarian object, may be protected as a work of art. So there's a slight exception to that rule. And as I alluded to, it's called utilitarian function. I think that's how they use the expression in the book. So those are examples of, despite meeting the three-part test, something will not be deemed copyrightable. All right. I do have one more. Oh, God, this is getting a little longer. Are magic tricks copyrightable? I thought this was a fun case to talk about, and I'll give you the answer in the short of it. I think this is in the book too. Is they are not copyrightable. They are elements that are in the public domain that are put together that don't lead to copyrightable protection. And what happened was, real quick, Rice had a video. The video was picking apart magic tricks, like why is this magic, or how to do the magic trick. And he wore, the top hat and dressed up like how you would visualize a magician. A few years later, Fox Broadcasting did the same thing, and he claimed that Fox Broadcasting copied him, took it from his video. And the court said, no, those are all in the public domain. Or sent a fair and used the description of the magician. We all know what a magician, that's a stock figure. Basically, the case put all of those concepts together that we just had talked about. But I just want to, I thought I had one more thing here to chat with you guys about, but I don't. And you're probably going, that's long enough as it is. A couple more. I just want to hit home this utilitarian function, because I don't have you in my class to ask you specific questions. But I just want to distinguish those two: instructions and rules, not protectable. So any owner's operating manuals, instruction for games, how to assemble a bike, how to use a camera, those things don't work. But key point here is these useful articles applies to that one category of works: the pictorial, the graphic, and the sculptural works. Okay? If the work is a useful article, it is protected only in its aesthetic features, and it's separated from its utilitarian aspects. Okay? Like a chair, you can see a chair, you can see a hammer, you can see a door. Think about that. An article having a utilitarian function that is not merely to portray its own appearance of the article or to convey information, it's not protected. So chair, hammer, door, each may portray its own appearance, but each one of those serves a utilitarian purpose. I think one of the examples I used early on was a mannequin. A mannequin is not protected. It looks like a sculpture, right? It's a sculpture, but it has a useful purpose. Okay, so that's the question you have to ask yourself when you're looking at something in the pictorial, graphic, or sculpture work area. Okay, now I'm done.